Thank you, Mr. Chair, and may I start off by rebutting the speaker over the other side, trying to draw a comparison with student unions and those people where education hasn't worked for them in life. And if the other side can't see the difference between those people who have made access and been qualified to go into university and those for whom education has not worked for, then that probably explains their failure when they were in government to having just forked money into tertiary education without any consideration, Mr. Chair, for the quality that comes out the other end. So this bill is long overdue. It's necessary because of the inactivity of the previous government and some of the conduct that we see there, especially, Mr. Chair, around the PTEs. And one of the very important functions of education in New Zealand, a sector of it, is the international education, the export sector it may be known as. And on clause 234B, it talks there about the necessary information that a private training establishment must provide for students. And this is very important because PTEs provide a very important function within the education sector, within the tertiary education sector. However, there has been cases where we've been all embarrassed with the lack of discipline that's been applied to the processes and how the student fees have been managed. And this part of the bill actually brings into sync the same functions around student fees and how they are carried out and sorted with regards to the other, say, universities and such like things. So international students and PTEs, how those fees are protected, their fees have to be put into a trust. And what is a trust? Well, it has to be at arm's length, separate from the PTE, the private training establishment. And as it says there in 234E, trustees means a public trust, a trustee company under the Trustees Companies Act 1967, a chartered accountant in public practice, or a lawyer whose practising certificate allows the holding of trust funds. So again, Mr. Chair, it becomes quite clear that there is process put around the management of these the student fees. Goes on there further over in 234E on Part 1. It makes the comment there, as soon as is practicable. And that was an interesting aspect because the Select Committee asked of officials what would be the definition of as soon as practical. And evidently it is a legal term. We were assured. To some of us, it appeared to be slightly loose, and however, they assure us that within the legal system, as soon as is practicable means reasonableness. And I don't know, they can sort that one out, but it is there. It was an interesting little discussion that we had with the officials. The process goes over that the Minister has a part to play in this. He has got to advertise in the Gazette that in actual fact how refunds of any student fees for courses have to be handled, and it talked about in this context the refund entitlement of international students. So again, there has been an issue, and this bill tidies it up again with regards to a private training establishment must allow every international student enrolled for a program or training scheme that is of 3 months duration or more to withdraw from it at any time within the refund period. And it goes through there and talks about the refund period, allow every international student in a course of less than 3 months within a period being less than 7 days specified by the authority. So, Mr. Chair, this bill really does tidy up a lot of those sort of rogue activities of the private training establishments. They are not onerous. It just writes out the rules, because really when we look at ourselves within the international educational scene, we have got to be able to provide certainty. we've got to be able to deliver a high standard of education, and this is what that bill does.
Sue Moroney.
Thank you, Mr Chair. Thank you for the ability